is ongoing puts him in a...
Well, let me ask you this. You've heard Ms. Loughran, and there's a very high bar before a subpoena to members of the press because of retribution, the fear of retribution. As she said, you're supposed to explore, supposed to negotiate, and we're aware of any negotiation. You say there are exceptions. You're supposed to try alternative sources. Let me ask you this. On what date did you recuse yourself?
I'm not sure. I think it's just towards the beginning of the matter. I don't know exactly when, but it was towards the beginning of the matter.
Isn't that a sort of an unacceptable procedure that you wouldn't formally, because the statute actually says that the Attorney General shall approve the subpoena. So shouldn't there have been some memorandum? There was no memorandum, no email. When you recused yourself, I mean, was there any, was it in writing? Was it orally? Who did you recuse? Did you alert the White House?
I certainly did not alert the White House. We don't talk to the White House about it.
Who do you recuse yourself to?
I would have told the Deputy Attorney General, as I have done in other matters, in the Edwards case, for instance.
Well, no, I understand, but do you not do that formally or in writing?
No.
Do you see any reason for a formal or there to be some memorandum so we know the time and date of your recusal?
Well, as I said, we have made a preliminary examination to see if there is anything in writing, but I know that I have recused myself in matters where I have not put something in writing.
Well, do you think that it would be best practice to memorialize that recusal?
I guess it might be helpful.
Well, it would be in this case because you apparently don't know when you recused yourself. Is that correct?
Well, I don't know precisely. I know that, as I said, it was towards the beginning of the investigation.
So it was before the subpoena.